All right. So, a very good evening, everyone. This is Raghav Singh on behalf of the Mentorship Project. I welcome you all in our next mentorship session, that is how to become advocate and record Supreme Court. And I'm glad to have with me my very good friend Anuja Pethia, who happens to be an advocate on record. She cleared the advocate on record exam in 2022 with rank 5. She graduated in 2013 from NLIU. After that, she also cleared civil services examination with rank 593, and she worked for some time as assistant director, Indian Corporate Services. Corporate law services. So, it is my pleasure to welcome Anuja here on this platform with us. You have been associated with us as an expert mentor for quite some time, and we are so happy to have you finally for a mentorship session on how to become advocate and record in Supreme Court.
Thanks, Raghav. Thank you for having me.
All right. So Anuja, let's start this conversation with the very fundamental question. Since most of the people who registered with for this mentorship session, the first these people are from law schools, and then there are some participants who are going to appear for advocate and record exam. But just to give these law students an idea as to who is an advocate and record and how this advocate and record is different from a normal advocate. So, for example, if there is a student who's there in a first year and he or she doesn't have any idea as to what is the difference between a lawyer and advocate and an advocate on record. So if you can just start this conversation with this.
Raghavan, so the Supreme Court of India has powers to make rules for its own administration and practice. So it has framed rules under which the Supreme Court rules, under which it has defined an advocate on record. So advocate on record essentially means somebody who's on the record of Supreme Court of India. And the only distinctive factor from other advocates is that only an AOR, an advocate on record, can file an appearance, file anything else, or represent or plead before the Supreme Court. So the purpose behind this was to have advocates who have an understanding of how the Supreme Court functions, because it's very different. The powers of Supreme Court are very different from high courts. I mean, for example, there's Article 142, which is extraordinary power to do anything to meet the ends of justice. Article 136 SLPs, it has original jurisdiction, which is unique to it, that is solving disputes between two states or the center and state, etc. So AORs are advocates who understand the practice and procedure of Supreme Court, and therefore there's an examination that they have to clear, and along with certain other criteria, so that they can better assist the Supreme Court in its functioning. So that's how AORs are different from other advocates.
All right. So all the advocates cannot appear in the Supreme Court. Is that the case, or
yes.
Can only?
Yes. I mean, other advocates can appear in the sense that can argue, but you cannot file and you cannot enter appearance without an AOR. So essentially, an AOR, if you want to argue before the Supreme Court, then you require an AOR to be there. So that's how the AOR is distinct. It has an AOR has a lot of responsibilities and duties towards the Supreme Court. So I mean, it sets a certain standard of practice before the court.
All right. So other other advocates can obviously argue before the court. So
for example, senior advocates.
Yes. For example, but they have to go through, or they have to enter their appearances through an advocate on record, because only advocate on record is entitled to appear and to proceed ahead with the filing.
Right. Absolutely.
Right. All right. So why would someone want to become an advocate on record? What are the benefits of being an advocate on record? For example, if somebody who's practicing in Delhi, he is going in various courts, for example, Delhi High Court, then there are various tribunals like TDSAT is there, and then income tax tribunals are there, and then even other courts are there, for example, Saket Court, and these district courts are there. So why would someone want to become an advocate on record?
So, first of all, it distinguishes you from other advocates. I mean, once you obtain a law degree, how do you know that what is the difference between two different lawyers until that person represents you in a particular case? So one thing is that it's an additional qualification. It's
right.
sort of a certification that you have qualified a standard which was set by the Supreme Court of India. So that is there. Apart from that, I mean, the exam in itself helps you learn a lot. Like after LLB, your learning curve in law, I mean, if you're a busy professional and not particularly into academics, your learning curve in law comes from the matters you handle. And when you appear for the AOR exam, the course is so vast. For example, in leading cases, I had to, I think, do 63 study 63 cases. So that really expanded my ambit of knowledge that is there. And it opens a new forum for you, the Supreme Court of India, which has like matters coming from all over. So especially if you're a lawyer like me, who's from somebody from outside Delhi, a lot of times you'll get matters from your home state. So
Correct.
for if you're an AOR, I mean, the person, the briefing counsel sending you a matter from your home state can trust you and knows that you know
Right.
way around the Supreme Court.
Right, right. All right. So if somebody who want to expand their practice apart from High Court and district courts and other tribunals, and in particularly in Supreme Court, then it is beneficial for that person to be an advocate on record, so that it would also help him to expand his practice. And at the end of the day, he can also help other people from where he hails. For example, you hail from a different place, but since now you are an advocate on record, then other advocates can actually rely on you when they have to go for the filing rather than some other advocate.
Yes.
All right. So, Anuja, apart from this, I wanted to know what is the eligibility to become an advocate on record?
So eligibility, you need to have 4 years of practice. This 4 years of practice can be in any forum. The last year, after 4 years, you need another year of practice under an advocate on record who has been an AOR for more than 10 years. You need to give your commencement certificate to the Supreme Court registry, which is you that you inform the registry that on so and so date, I am starting my legal training under this AOR. After that, when 1 year gets over, you get an internship, the training ending certificate, and then you submit that to the registry. So for minimum 5 years of practice, where 1 year is with an AOR. Apart from that, you shouldn't have any professional misconduct cases or anything else against you, and you need to, of course, qualify the AOR exam after that. So these are the criteria.
So just to be clear, Anuja, when you talk about 5 years of practice, so this practice has to be particularly in Supreme Court or even in High Court or other courts and forums as well, just to be clear.
No. So 4 years can be in any court, district court, High Court, Supreme Court, anywhere, but your last year has to be under an AOR. So you can bifurcate it into 4+1, where the last year, 1 year, you learn with an AOR. Because anyways, I mean, if you don't know Supreme Court practice, it's very difficult to clear the exam. If you need to appear there regularly or, be familiar with practice and procedure to clear the exam.
Right. So 4 years of practice in any court in India or particularly in Delhi?
No, in any court in India.
In any court in India. Yeah. All right. Because most of the people are having this misconception that if you have to appear for AOR, you have to practice in Delhi itself. No. So this is not the case. All right. So now let us talk about, since we are done with the eligibility criteria, let us talk about the structure of the exam. How this exam and how one should prepare for this exam. So let us talk about the structure first.
Okay. So the exam has 4 papers, 4 question papers. First is practice and procedure of the Supreme Court. Second is drafting. Third is advocacy and professional ethics. And fourth is leading cases. Now, the exams are typically conducted on 4 consecutive days. They are of 3 hours each. And except leading cases, leading cases is the only open book exam. Apart from that, the 3 other papers are not open book. So that is the structure of the paper. Four papers on 4 days for 3 hours. And they're subjective in nature, not objective. All right. So then I think this is another one very important fact that you've stated, that it is subjective in nature, and you have to, it's not there on the system, right? You have to write it. No, I mean, the Supreme Court has been considering doing it over the system, but so far it hasn't been implemented. So it's a paper and pen exam. You have to write a lot. All right. Okay. So this is something which is again crucial for a lot of lawyers, because once you start practicing, there's very little time you get to write as such with a pen and a paper. So this is a challenge. Now let us get into each paper as such, paper 1, 2, 3, 4. So what are these paper, and
particularly since you were among top five candidates in the AOR exam 2022. What was the strategy and how did you prepare for individual papers? So let us talk about paper one. So what is paper one?
So, paper one is practice and procedure of the Supreme Court. It is, I would say, it's the most time-consuming syllabus after leading cases because you have to memorize stuff. I mean, there's so practice and procedure involves knowing the Constitution of India, what the particular section that deals with union judiciary, which gives powers to Supreme Court. So, all of that you need to know really well. There are case laws on it, and secondly, you need to know the Supreme Court rules really well. So that's that. I mean, essentially, I think these two are the source of paper one. But having said that, it's much like, it sounds much easier because there appear to be two sources only, but Supreme Court rules are quite complicated and you have to memorize them. So what I did was that first thing I did was that I analyzed the question papers of the previous years. They are all available on the Supreme Court website. So what you can do is that you take out 10 years question papers of practice and procedure, and then you divide topics. For example, number of questions that have come on original jurisdiction, or the number of questions which have come on chamber judge. So Supreme Court. So all of this you can divide, and then according to the importance and repetition of every topic, you start preparing for the paper. So practice and procedure, I strongly suggest. I mean, that's how I did it. I first thing I did was, before picking up any book, I did the Supreme Court rules. I just picked up the Bare Act and I went through it again and again and again till I could memorize it. After that, I picked up. There's a book which you get from the Supreme Court. I think it's from EBC probably, which is on practice and procedure. So that has a lot of case laws on Supreme Court rules. So you can then, remember some important case laws. Of course, you don't need to remember all case laws. And after that, I mean, there is the Constitution. So Constitution, Union Judiciary chapters, I mean, all the cases that are there are quite landmark. So if you've been practicing for 5 years, you'll most probably know that. So the most difficult part is to remember the Bare Act, for example, because, there are questions which are very repetitive. For example, what are the powers of a chamber judge? Which applications get listed before the registrar, which go before a chamber judge. So things like that. So practice and procedure, you must do again and again, remember, memorize, and it's the most time-consuming syllabus, I think, in all the 4 papers.
From where did you get the material for this paper?
So the Bare Act is available. I mean, that's there. Apart from that, I think the EBC material was available for download on the Supreme Court website. If not, then you can just ask a friend in Supreme Court. Near around the exam, I think in the library or somewhere they sell the material. I had asked my clerk to get it for me, and otherwise, I think on Amazon also that EBC book is available. But a lot of us who take the AOR exam are working professionals, and there's, of course, the paucity of time. So if you have that, you don't have to go for any books. My suggestion is that if you thoroughly go through only the Bare Act and the Constitution articles, you will get passing marks.
All right. And what is how many marks one can score in this paper? Like, what is the highest marks which could be given in this paper?
I mean, it can go up to 80, 90.
All right.
I mean, all papers are 100 marks. So I'm not sure, but I think I scored around 80.
Wonderful.
Yeah.
All right. So you can say that it is one of those papers where you can have an edge, because there's a limited resource which is available, and that resource is available with all. So if you go through that resource again and again, so there are chances that you can get good marks in this paper.
I think it's one paper where the number of hours you put in will show in the marks you get. So because it's completely theoretical. And if you have been practicing in Supreme Court, it becomes easier because, for example, chamber judge has like 40 applications or 40 powers, if I remember correctly. So, I mean, if you've been appearing there regularly, you know it already. So there are things like that. So if you can practice before Supreme Court, it's always great. If you can't, then you need to put in more time to remember the Bare Act.
All right. And roughly how much time did it take for you to memorize the Bare Act?
I mean, for the entire preparation, I took 2 months.
For all 4 papers?
Yeah. And I tried to do practice and procedure. I think I did it properly once, and then I did another revision. So, and I also made some short notes on topics that were repetitive. Like when you go through the 10 years question papers, you will realize that there are 5, 6 topics that are very, very frequent. So if you just make notes on them and cover that, I mean, the point in this examination is that you don't need to get a rank. You just have to pass to get a qualification. So I mean, you need to be 50 marks and above. So even if you just go through the question papers thoroughly, you can identify what's going to come in the paper.
Probably your habit of making notes in civil services, examining, doing it might have helped here as well. Because again, once you come out of the law school and you start practicing after 5 years, taking a pen and a paper and preparing notes is like it's next to impossible. So this is something which was very, very helpful. And again, this is a good advice for all the aspirants for this exam. All right, Anuja, let us go move forward with the second subject, which is the second paper, which is drafting.
Yeah. So drafting is a tough paper for a lot of people. I think this year also, I mean, I don't have any concrete statistics. I mean, from the WhatsApp groups that I was part of, I got a sense that the drafting paper has the highest failure rate. And that is because I mean, you are expected. So I'll tell you first, what does drafting paper cover? So you are expected to know how to draft a writ petition under Article 32, how to draft a writ petition PIL, how to draft an SLP criminal, SLP civil, a civil appeal, a criminal appeal, affidavits. There are certain certificates that an AOR has to give with an SLP, applications. So all of that you need to do. And the drafting paper, when I took the exam, I mean, the problems were of 2 pages each. So within 3 hours, you have to read a 2-pager problem. You have to apply law in your head, and then you have to draft an SLP by hand. So the problem is that, like, even for practitioners before Supreme Court, we are used to taking drafts on MS Word. So we'll never pay attention to, for example, in the Supreme Court of India, order number so-and-so, rule number so-and-so, most respectfully show it, or the contents of the affidavit. All of these things are things that we don't do as practicing lawyers. But in the exam, you're expected to remember it and write it down. So it becomes really tough for people to complete that paper, first of all. I mean, I think in drafting, if you complete the paper, you are going to pass, but most of the people are unable to complete the paper. And apart from that, if you're used to drafting SLPs and writ petitions, then it becomes easier. So what I did was, my strategy in drafting paper was to save time while preparing, because drafting paper, according to me, was one paper where there's no memorizing. I mean, in 2 months, you can't learn law, right? So you can only draft whatever comes on the basis of knowledge that you have already. So what I did was I focused on remembering affidavit, remembering certificates. I made formats of SLP, like just the header and the different sections. So an SLP, for example, has fixed 7 paras. So if I might be forgetting now, but I think it has fixed 7 paras. So just remember those headings, and the prayers are fixed. So remember the fixed parts, and in the middle of it, I mean, just do what you can do in the exam. So drafting paper didn't take too much time for me to prepare. I think I gave 3-4 days to it. I remembered, I just memorized the formats and applied the law when I was writing the paper. But yeah, I really focused on completing the paper. Even then, I missed like a little bit of it, but that's what I did. So in drafting, you must complete the paper. If you're somebody who's not used to writing, you must do writing practice. Otherwise, drafting paper is very difficult to clear.
This is very, very interesting, because as we already know, that drafting is one art which cannot be, somebody cannot teach this to you unless you yourself do it and practice it. And the problem which is there right now in most of the law schools as such is that although there might be a subject which is relating to drafting as such, but then there are samples which are given which do not encourage creativity as such, which do not encourage application of mind. So unless you get into that practice area, you are having a very myopic view of what drafting is. So in this context, I wanted to ask you that since you said that you were already practicing in Supreme Court, and that is why you kept on drafting petitions and SLPs. So that is why this might be convenient for you when you were preparing for this paper. But there are other aspirants who might not be practicing in Supreme Court but interested in giving this exam. So what advice would you like to give those people who are not having fair idea about how to draft these petitions and SLPs and other documents which are filed in Supreme Court?
See, the first thing I would say is not to get intimidated, because the essence of draft is the same everywhere, which is to, there is a list of date in every draft that you prepare. There are grounds, there is synopsis.
Right.
Like somewhere there in an SLP or a civil appeal also. So you must focus on remembering the format. The format is very different from what we are used to, what one might be used to in a high court or district court. Once you remember the format, then whatever, when the question
Right.
comes, just apply the law and facts. I'm certain that there will be one question on criminal law. All of us are aware of criminal law in whatever, whatever capacity. And there'll be one question on civil law. Will be one PIL. For example, I had a question on original powers of Supreme Court. So that is something I had never drafted before. I mean, because it's rare. But before the exam, I had called for samples from some other aspirants who were preparing and went through it. So just call for samples, and for friends who might be practicing, just go through SLPs and how they are done, and don't focus on merits too much. I mean, of course, you can't write something that is completely irrelevant or illogical, but more than merits, it's again knowing about how to what is the format and how do you present a case. So
Right.
as long as you can apply logic, and even if you know law a little bit, I think you will pass. So, I mean, a lot of people are intimidated by it. I would just suggest that don't be scared. I mean, just complete the paper. So,
all right. All right, Anuja, one more question. Now, this question is relating to format. All right. So, like most of the people say that, you need to know the format, and then you can you can go forward with that. If you know the format, you need to apply law and all. From where does one get a format? Because there are so many resources available online as well. There are one fine day I was going through Instagram that there was one resource which was available which said that it had more than 2,500 formats in one PDF. So
no,
like that. Yes.
Yeah, so no, there are not 2,500 formats. I think for this exam, you only need to remember 7 to 8 formats. And the best source is the Supreme Court website. So if you go to Supreme Court website, there are forms available. Like I think there is a draft, like, headings of writ petition PIL. There is a format of writ petition. And I think they are there in Supreme Court rules also. So what I did was that I went to the Supreme Court website. I downloaded those one or two pager formats, because I mean, what is a more reliable resource than the website itself?
Obviously.
And if I couldn't find something, then I took out, I asked for my friends, asked for samples from my friends, and I did that. I mean, it's not, see, the thing is that it's not very technical, because the people who are setting your paper and checking your paper are all senior lawyers. Right. So it's not going into a computer where if a particular heading is even slightly different, your marks will be deducted. So even if it's 90% similar, formats will vary from like a little bit. So just follow the Supreme Court website, call for samples from your friends who are practicing in Supreme Court, and I think that should be good. But there are just 8-9 formats. There are not a lot of formats that you need to remember for drafting.
So the questions which are asked in this particular paper, they would only be asked with these 8 to 9 formats which are available.
Yes. Writ petition, PIL, SLP, civil SLP, criminal, civil appeal, criminal appeal, original suit. So I think it's 8 or 9 formats. That's it.
All right. Now, since it is a drafting paper, then obviously completing it would be a challenge. That since you need to apply your mind, and it is not only a format. So another question is how are these questions framed? Are these principle-based questions which are there in the AOR exam when it comes to drafting, or is it just 2-liners question or 3-liners questions which are there? One can just assume facts and carry on with the drafting.
No, so all the facts are given. Every question, I think, is at least 1 or 2 pages. So typically, I think I had calculated 35 minutes that you get to draft one draft. For example, SLP civil. So all the facts are given. You have to take out everything from the question only. There's no need for any assumptions. All the facts will be given to you. So you have to also need to read very quickly, because if you take 15 minutes to read the question, then you'll barely have 20 minutes to draft. So
again, very, very important piece of information we have given here, and most of the people assume that since it is drafting, then they need to have a good speed at writing, but then you need to have a good speed at reading as well, because once you say that it is 1 or 2 pages questions, then obviously you need to have a very good speed at reading and then grasping what are those essential things that you need to take it out and reproduce in your answer. All right. So how did you practice? Did you go for, are there practice papers available, or you just, since it is there in the normal course of business or a normal course of practice as such, that you have to file SLPs and a petition? So did you practice particularly for this paper, or was it just your
No, I did practice because I had to time myself to. I mean, typically, if I draft an actual SLP, I'll take, I don't know, 2 days, 3 days, call for papers, analyze all of that. But over here, I had to do the same thing in half an hour. So I did practice.
right?
The first thing I did was I ratified the format, the certificate, the affidavits. And then I took last year's question paper and I timed myself in 35 minutes, and I drafted it like that. But I mean, if you do it once or twice, you just need to get a pace of yourself, like how much time you're taking, because facts won't be repeated. Once you remember the format, you just need to have a timer in your head. Ki by the time it's 15, by the time it's 10:15 a.m., the paper starts at 10 a.m. So by the time it's 10:15 a.m., I should have been done with my list of dates and should have started on the ground. So that these time markers you should have in your head before you enter the exam hall.
Okay. All right, Anuja. Let us move towards the third paper.
Yeah. So the third paper is Advocacy in Professional Ethics. So for this paper, I mean, the most important source is the BCI rules. BCI has code of conduct and rules for lawyers. So you need to remember that is something which you can use repetitively in different ways in all regions. Apart from that, I relied on a book. It's called Professional Ethics and Bar and Bench Relationship. It's by LexisNexis. I found it very helpful. And also there is this A.K. Jain's book on professional ethics. I don't know what the you students call it, Dukki. So I use that for case laws. There are a lot of case laws in it and very good case laws. So these three are the sources I relied on: BCI rules, professional ethics book by LexisNexis. It's a very thin book and a very useful book, and A.K. Jain's Dukki, or professional ethics book for all the case laws. So this was more than sufficient for professional ethics and advocacy. Apart from that, there are there are few landmark judgments on duties of an AOR that you can easily find online. So the Supreme Court website has some very good material on this particular paper. So if you just download that also and read it, you'll find all the case laws which are related to AOR. So 4 sources: the BCI rules, Supreme Court website downloads for the cases on AOR, LexisNexis book, and A.K. Jain's book.
So what are the kind of questions which are asked in this book?
So when I took the exam, the questions were the duties of an AOR, what is misconduct for an AOR, what is soliciting, what are your views on advertisement by lawyers. So largely based on BCI rules only. So yeah.
So there are no fact-based question or application of mind-based question where
no, not really. It's completely theoretical as far as I know.
So. All right. Okay. So I think out of these 3 papers, the third one is something that one can actually consolidate on, because again, the resources are limited and the kind of questions which are asked, they are also straightforward.
Yeah.
Let us move forward with the last part or the last paper.
Yeah. So leading cases was the last paper, which was very, very tough. Even though it's an open book exam, there is barely any time for you to actually open the book and go through it while you're writing the exam, because it's a very lengthy paper. I think there are 5 questions. And so when I took the exam, there were nearly... I'll tell you. There were 64 case laws that we were supposed to read. And if you see the last year's question paper, there is a tendency for examiners to ask about dissenting opinions also. So you really do need to go through the judgment thoroughly. I mean, you can't just go on some website and read a summary. You need to know the law. You need to know the judgment. So this is the paper that took the most amount of time for me to prepare, apart from practice and procedure. So what I did was I went through the case law, I prepared notes on it, I tried to prepare 2 pages on every case law that I went through, because
Mhm.
there's only so much you can remember. So that's what I did. And I mean, when you start preparing for this, my suggestion is that if there are 63 cases, and I mean, I think they increase every year,
Mm.
you shouldn't go by it sequentially. What you should do is that identify the subject matter of each case law. For example, in the 63 case list, there will be 3 or 4 case laws which are related to insolvency. So you
Mm.
study those 4 case laws together, because then you
Got
can
it.
correlate. And the question that will come will be typically in insolvency
Mm.
or judgments on insolvency. So that's a much better way for you to remember, correlate, and also draft your answers. So the first thing you should do is categorize the case laws into different subjects, and then study them subject wise. Try to make notes, because you need to revise one day before the exam and you cannot
Mm.
go through the entire judgments. So that, apart from that, I would suggest that you should carry flags in the exam hall for this
Mm.
paper, because if you in the first 2-3 minutes you can just flag the questions that you're going to answer. You can flag
Mm.
the case laws that the hard copies that you're given. You
Mm.
can put flags so that if you forget something and you have to look, you can just open that page quickly. There's no time to locate something once you're writing.
All
So
right.
yeah.
Mhm. Okay. So the 64 cases that you're talking about, I don't know if I've missed out on this point. Is the list given by the Supreme Court itself that these are the 64 cases
Yes.
where?
So every year, the Supreme Court, when the notification for the exam is taken out,
Mm.
the syllabus is given, in which the first 3 papers, largely the syllabus remains the same. And for the fourth paper, there is a list of cases that is given to you. And eventually, I mean, all the cases are also uploaded
Mm.
on the Supreme Court website. So
Mm.
you don't have to run anywhere for SCC or SCR downloads or books. You can just download it from the Supreme Court website and study it from there.
All right. And what are the kind of questions which are asked? Is it like what was the ratio in this particular case? What was the obiter in this particular case? Or what are the kind of questions which are there in this paper?
So the questions which are asked is that, for example, they can pick up a line from any judgment and they can ask
Mm.
you कि ये किसने बोला था, और
Okay.
for example they can ask you कि ललिता कुमारी में what was the ratio, what was held, and
Mm.
narco analysis पे they can ask you questions.
Mm.
They can ask you questions on dissenting opinions. In the year I took the paper, I don't think there were any questions on dissenting opinions, but prior to that there were always questions on dissenting opinions of judges.
Mm.
So for example, AR Antule is a very complicated case that's always
Mm.
there each year. So in that also
Mm.
there are varying opinions. They can ask you about different opinions.
Okay.
So I mean, once you read the case laws, you'll just understand, like once you read the case laws and past year questions, you'll understand what sort of questions are being asked. But for leading cases, you really do need to know the case law through and through. So
Mhm.
for that is something you need to be prepared for. That is the paper which requires the maximum amount of reading and
Okay.
making notes.
All right. So my next question is that since you have to go through so many cases, like 64 cases, and in any case you have to go through, is there a question asking about your opinion? As in, this was the decision which was there, and whether that you need to comment on that decision, whether that decision was right, wrong,
Yes.
something.
I
Because
think there is, but again, that will be a very tiny part of the question. I mean, if there
hmm,
is a question which is asking for your opinion, 70% of it will be there'll be questions preceding it where you have to talk about the facts of the case and the opinion that the judges gave. And after that, probably what you think of it will only be a paragraph or something like that. So that's not
all right.
something, yeah.
So my why I ask this is that because if there is a judgment, and again this is very tricky because some people might be very critical of a judgment which has been accepted by a certain section of the society. So would it be against that candidate if he opines? For example, let us take for example that there is a case right now which is everywhere in news, the same-sex marriage with a case which is going on in the Supreme Court. Finally, Supreme Court tomorrow comes up with a decision, and the decision which is there, it is listed in your syllabus of AOR, and then somebody in that opinion says that they do not agree with the decision, and it might be a split verdict, it might not be a split verdict. So, how that opinion would fare against the person who has actually written it, and would it be advisable? That is the first question, to write or to criticize the judgment which has been asked.
See, I mean, it's you shouldn't take extreme views, and I mean, I think the people who are taking the exam should remember that at the end of the day, you are lawyers, and this is a law exam. I mean, you're not writing this as a law student anymore. So, even if you are against, let's say, the same-sex marriage judgment, you should support it. You should answer that only basis law. I mean, if you follow the arguments right now, also there are people who are opposing the same-sex marriage legalization, but it's I mean, none of the arguments are emotional, they're all based on law. So if you can substantiate your view by like quoting some law or article or past judgment, sure, I mean, you can write it, but you should appear to be logical, not illogical. But having said that, I mean, if you are taking an exam, you never know who the examiner is or what point of view he has, so you should never take extreme views. I mean, you can just give pros and cons, like 2 points in favor, 2 points against, and then be like, I would suggest that I am against it for because of the 2 points listed above. So, I mean, it shows that you are somebody sensible and you have a balanced view of the problem. And you have given 2 points in favor, 2 points in against, but you support the 2 points against this particular subject. So, I think that would be a better way of going about it.
So even if they would ask that comment, then you can comment both ways, in favor as well as against it. Is that what you're saying?
Yeah, I mean, that's something that we were taught while we were taking UPSC because UPSC has a lot of opinion based questions
Yeah.
and we don't know who's taking. So we were always told that, you can always give a balanced view, 2 points in favor, 2 points against, and be like, yeah, I am supporting this particular view because of that. So, I mean, I think it should be just logical and based on law. As long as it's based on law, I don't think it'll be an issue because, I mean, the people who are checking your papers are senior advocates. So they are used to having views from different sides. So, I mean, they're seasoned lawyers. So, if you can substantiate your argument, sure, I mean, write it.
All right, so you got fifth rank, so obviously this is a hit when it comes to this practice. So I think I would advise all the aspirants that if there is a comment, this if you are appearing for this paper and there is a question where it says that if you would want to comment on this, then do not take a very radical view or extreme view. Go for the strategy which has been told by Anuja here. All right, Anuja, now that we are over with this preparation part, so I think this is it. On an average, how many advocates are selected as an advocate on record in Supreme Court? And how many students, if you are aware of this, if I may ask that, how many aspirants appear in this examination?
So when I had taken the exam, I think there were 800. I'm not sure. And typically the pass percentage is 19 to 20%.
All right.
So yeah, this year I think 260 advocates became AORs.
All right. Okay. So the point is that you need to have a structured preparation, and you need to know what the syllabus is, and the chances are that if you carry on with that structured preparation over a period of time, you will get through. Now, let us talk about the practical aspect of advocate on record. So, say somebody who is having a practice in income tax tribunal, income tax appellate tribunal, or TDSAT. So, if he becomes an advocate on record, and he might not have gone to Supreme Court, or he might not have a constant practice in Supreme Court. So once he becomes an advocate on record, what should be the strategy for that advocate? Like, should he, since now he has got this stature of advocate on record, should he concentrate his practice towards Supreme Court more?
I mean, I don't really know. See, as a first generation lawyer, you don't know where the briefs come from or where clients come from. So yeah, I would say that after you become an AOR, I mean, there surely is an acceleration to your practice. I mean, I also have felt that personally, that my practice has increased after I became an AOR. But I mean, I don't know. I mean, it's very difficult to define which direction. If you have the liberty of choosing a forum and you have a lot of briefs and you can take your practice to Supreme Court, then yeah, I mean, of course you should, because it's a great forum to practice in. But I don't know if how many people have that liberty.
All right. Obviously, it's a little bit of subjective question, but the reason why I asked this is that time and again Supreme Court has come forward and told that just because your signature is there as an advocate in record doesn't mean that that is your only duty.
Yeah.
And most of the time, advocate and record, in past we have observed through various news reports, etc., that these people do not appear and they just use it as a tool to gain or to have an income and not to be
Yes.
involved in the case as such.
Yes, that's absolutely correct. In fact, name lending is a misconduct for an AOR. You can't just, sign and stamp on a particular pleading before Supreme Court and shirk all responsibility. I mean, there is a purpose for, there's a purpose behind why there is an AOR. So if you do take up a brief or, do any filing in your name, you must ensure that the pleadings are proper in proper format and that you are involved in the matter. I mean, it's okay if somebody else is drafting it, but you have to vet it. You can't just blindly sign it and stamp it. You have to go through it and ensure that there's everything is in proper order. If there is another arguing counsel, you must always be present in court. Recently, I think one of the benches has observed that verbally that an AOR must always be present in court, even if there is an arguing counsel. So that is there, and I also strongly discourage this practice. But yeah, I mean, there are people who do it, and there are landmark cases on this as well, which you will study if you take the exam. So yeah, I mean, if you are moving, yeah, if you become an AOR and if you are moving your practice to Supreme Court, you shouldn't just do name lending. You should be there and get involved. I mean, that's how you enjoy the practice also. I mean, what's the point of being an AOR if you're just, signing and putting your stamp on some pleadings? You you should argue, and that's where all the fun is, right?
Correct. Correct. All right, Anuja, that was very, very informative for me personally, and I hope that for all the participants as well. Now, I think the house is open for questions. So, if any of the participants have any questions for Anuja, they can go forward and they can ask. So I think that there are no questions. So again, thank you so much, Anuja, for your time. And it was great having you with us. And you have been a part of this project since the very inception. And having you here is again a pleasure for all of us, not only in terms of the knowledge that you have given, but also in terms of accessibility. Because I remember that there have been so many students in the past, apart from this general mentorship that we are given, there are people who we think do not have access to proper mentorship just because of their background, just because they are the first generation lawyers. So as you already know that through this forum, we are providing that mentorship to those particular students. And again, I think you are already aware, because we are sending mails of our achievement as well, that very recently 5 of our mentees, they have become judicial officers in Madhya Pradesh. One mentee has cleared Delhi Judicial Services exam this year itself. 2 of our mentees are law officers in Coal India, and 2 of our mentees are law officers in Bank of Baroda, and 2 of our mentees very recently they have become POs, and this number will only get to grow. Why? Because we are having people like you with us, and we are very thankful to you for your time, for your energy, for your effort, and we wish you all the best for your endeavors, for future endeavors as well. And we'll keep bugging you when any student comes to us after watching this thing on YouTube and ask that I want to have a discussion with Anuja ma'am because I have these doubts.
Yes,
So
yes.
again, Anuja, thank you so much for your valuable time.
Thank you, Raghav. I hope mentorship project keeps doing well and helping a lot more people.
All right. Thank you so much, Anuja. Thank you.
Bye. Bye. Thank
Bye.
you.
Take care. Bye.